These 5 words are all you need to end any police stop in 2 minutes or less, and almost nobody knows them. Most drivers sit at the side of the road for 10, 20, even 40 minutes, answering questions they were never legally required to answer, all because no one ever told them what 5 words can do to a traffic stop. The moment you say these words, correctly, calmly, and at the right time, the officer is legally obligated to either produce a specific reason to keep you there or let you go. Before I show you exactly what those 5 words are, go ahead and subscribe right now and turn on notifications, because this channel is dedicated entirely to giving you the legal knowledge that protects you in real situations. Here is the legal reality of what a traffic stop actually is. When an officer pulls you over, that stop has a defined legal purpose. A broken tail light, a speeding ticket, a lane violation. Whatever the stated reason is, that reason is the entire legal boundary of the stop. The officer is permitted to do what is necessary to address that specific purpose. Check your license and registration. Run your plates. Issue the citation or the warning. And then the stop is legally over. That is it. That is the full scope of what a routine traffic stop is authorized to do. But what actually happens in the real world is entirely different. Officers are trained to extend that scope. They ask questions that have nothing to do with the reason for the stop. They hold onto your documents longer than necessary. They create small talk that keeps the conversation alive. They make requests that sound like commands, but are completely optional. And while all of this is happening, drivers sit there and participate because they do not know they have a way out. They think they are required to answer every question. They believe they have to wait as long as the officer decides the encounter should last. They confuse being polite with being legally compliant. None of that is true. The moment the purpose of a traffic stop has been fulfilled, you have the right to leave. The problem is no one has ever told you how to trigger that right in real time, out loud, in the moment. That is exactly what these 5 words do. Let us get into the first and most critical part of this, which is the 5 words themselves and the precise moment you say them. The 5 words are, "Am I free to go?" 5 words. That is the entire phrase. You say them clearly, without attitude, without aggression, without apology. Just 5 words delivered as a direct legal question at the exact moment the legal purpose of the stop has been completed. Here is the legal reason this works. Those 5 words force what attorneys call a legal binary. The officer must place you in one of 2 categories the moment you ask. Either you are free to go, meaning the stop is over and you can drive away, or you are being detained, meaning they have a specific, articulable legal reason to hold you, and they are required to tell you what it is. There is no third option. There is no hang on a second or let me just finish up here. When those 5 words are spoken, the law demands a direct answer. Here is exactly how, and when you use them. The officer has handed back your license and registration. The citation or warning has been issued or communicated verbally. The legal purpose of the stop is complete. You look at the officer and you say, "Am I free to go?" Nothing more. Nothing attached to it. Let me show you what happens on both sides of this decision. The wrong approach. Most drivers sit and wait after documents come back. The officer leans in and says, "Hey, before you go, let me ask you something." The driver says, "Sure." That one word, "sure," just reopened a stop that was legally finished. The driver handed control back with a single syllable. The right approach. A driver who knows these 5 words asks them the moment the documents are returned, "Am I free to go?" The officer either says yes, and the stop is over in seconds, or says no, and now the driver immediately knows they are being detained and has the right to ask why. Either way, Those 5 words have just produced complete legal clarity in under 10 seconds. This is protected by the Fourth Amendment, which prohibits unreasonable seizures. A traffic stop is legally classified as a seizure. It must end when its purpose ends. The Supreme Court made this explicit in Rodriguez v. United States in 2015, ruling that extending a stop even briefly beyond its legal purpose, without independent reasonable suspicion of a crime, is a constitutional violation. Your 5 words are the real-time application of that ruling. Defense attorneys use exactly this question to establish in court the moment a stop became legally excessive. When you ask it and the officer continues holding you without a clear answer, every moment after that question becomes legally significant. Have you ever sat at a traffic stop not knowing if you were allowed to leave? Drop a comment below and tell me how long you waited before you said anything. The numbers are going to be remarkable. Now let us move to the second layer, because knowing the 5 words is only the first half. The second half is knowing what to do the moment the officer says no. When you ask, "Am I free to go?" and the officer says no, that is the moment most drivers fall apart. They feel like asking was a mistake. They feel like things have just gotten worse. That feeling is exactly what experienced officers are trained to produce, because panic makes you talk. And talking is how stops escalate. Here is what you need to understand about the word no in this moment. When an officer says no to your 5 words, they have just done something that benefits you enormously. They have confirmed that you are being detained. Detention is a legal status. It comes with specific rules, and those rules work in your favor when you know them. The moment you hear no, you respond with this: "Why am I being detained?" Not aggressively, not loudly. 5 calm words that constitute a direct legal question requiring a specific, articulable answer. Not a gut feeling. Not general suspicion. A real, specific reason the officer can say out loud and put on the record. The wrong approach. Most drivers hear no and immediately start explaining themselves. "I was just asking. I have somewhere to be. I did not mean anything by it." Now the officer has fresh conversational material, and the stop extends further on their terms. The right approach: the driver hears no and immediately responds with "Why am I being detained?" and then stops talking completely. The officer must now produce a reason. If the reason is valid, you know exactly where you stand. If the reason is thin or non-existent, your attorney now has something concrete to work with. This is grounded in Terry v. Ohio from 1968, which established that an officer must have reasonable and articulable suspicion to detain someone beyond the scope of the original encounter. In plain terms, they need a real specific reason they can say out loud. Asking why you are being detained forces that reason onto the record in real time. Now let us add the third layer, which is the silence protocol that keeps your 5 words from being undermined. Here is the part most people miss entirely. Your 5 words only work if you stop talking after you say them. That sounds simple, but it is one of the hardest things to actually do in this situation. Silence feels uncomfortable. Silence feels rude. Every social instinct you have developed over your entire life is telling you to fill that quiet space with something reassuring. But in a police encounter, silence is not rude. Silence is protection. Officers are specifically trained to use silence as a tool against you. After you ask your question, many will simply pause and look at you. They let the quiet grow until you cannot stand it anymore. Then you start explaining. You start softening the question. You apologize for asking. And just like that, you have walked yourself back into the conversation you were trying to end. After you say, "Am I free to go?" you say absolutely nothing else. 0 words. You look at the officer calmly. You breathe. You wait. If the officer responds with a question rather than an answer to yours, you say this: "I would prefer not to answer questions without an attorney present." Then silence again. You have answered with a legally protected response and given them nothing new to work with. The wrong approach. The driver asks the question and immediately undercuts it. "Sorry, I am not trying to be difficult. I just really need to get going." The officer now knows the silence is making the driver uncomfortable and uses the discomfort to keep the encounter alive. One more question. One more answer. The stop continues. The right approach. The driver asks, "Am I free to go?" and closes their mouth completely. The officer eventually either answers or begins moving toward resolution. Your silence forces their hand just as effectively as your words do. This comes directly from Supreme Court protections around the right to remain silent, and the safest way to invoke that right is verbally, as in saying you would prefer not to answer questions without an attorney present, and then actually staying silent. That combination is the complete package. Let us lock all three layers together with the legal cases that make this entire system unbreakable. The first is Terry v. Ohio from 1968. Officers must have reasonable, articulable suspicion to detain you beyond the original purpose of the encounter. Your question, "Why am I being detained?" forces them to produce that suspicion out loud and on record, in the moment where it matters. The second is Rodriguez v. United States from 2015. The Supreme Court held that a traffic stop cannot be extended beyond its original purpose without independent reasonable suspicion of a criminal offense. Your 5 words, "Am I free to go?" are the direct, real-time application of this ruling every time you say them. The third is Florida v. Bostic from 1991. The court ruled that a person is free to decline an officer's questions and requests provided they understand they have the right to do so. Your silence and your invocation of the right to counsel are both protected conduct under this case. These 3 rulings together are the legal foundation that makes everything you are learning in this video not just practical, but constitutionally protected. Now let us walk through a complete real-world scenario with all 3 layers working together. It is 8 in the evening. You are driving home. An officer pulls you over for rolling through a stop sign. You pull over immediately, park the car, and keep your hands visible on the wheel. The wrong way. The officer asks where you are coming from. You explain your whole evening. He asks if he can take a quick look around. You say sure, because you want to seem cooperative. He spends 19 minutes searching your vehicle. Something in the back seat leads to a new line of questions. You are on the side of the road for 45 minutes explaining things you never had to explain. The right way. The officer asks for your license and registration. You say your documents are in the glove box, and you are going to reach for them now. You hand them over. He asks where you are coming from. You say you would prefer not to answer questions without an attorney present. He runs your information, issues a warning, and hands your documents back. The moment those documents are back in your hand, you say, "Am I free to go?" He pauses. You say nothing. You wait. He says yes. You say, "Thank you, officer, have a good evening." You are gone in under 8 minutes. That is what knowing the law actually looks like in practice. Coming up next week, the complete word-for-word script for what to say when an officer tells you he smells something coming from your vehicle. That claim is being used to justify warrantless searches every single day, and the verbal response that actually holds up in court is one almost no driver has ever heard. Subscribe right now, because that video is coming in 3 days, and it may be the most important one on this channel. Here is your complete recap. The 5 words are "Am I free to go?" and you say them the moment the legal purpose of your stop has been completed. If the officer says no, you immediately ask, "Why am I being detained?" and then you stop talking entirely. Silence after your question is legally protective, not rude, and you hold its silence until the officer answers or until you verbally invoke your right to remain silent. These three moves together create a complete verbal framework that ends stops on your terms, using rights the Constitution already guaranteed you. If this video gave you something you are going to actually use, subscribe right now so you do not miss what is coming next. Every video on this channel is built around one goal: making sure you know your rights and know exactly how to use them when it counts. Stay sharp out there.